Thank you, Madam President. I'm proud to present Assembly Bill 495, the Family Preparedness Plan Act, on behalf of Assemblymember Celeste Rodriguez, that strengthens policies to keep families together in the face of mass immigration actions. 1 million children in California have at least one undocumented parent, and over 100,000 children in our schools are undocumented themselves. Assembly Bill 495 provides families with education, options, and support in the case of family separation. This bill creates joint guardianship in the probate court that would allow a parent to preserve their paternal rights or granting joint guardianship to another person to care for their child in the event of a parent's absence. Assembly Bill 495 strengthens parental rights by ensuring that a person's guardianship nomination is given due weight in court. And Assembly Bill 495 requires the Attorney General to publish model policies limiting assistance with immigration enforcement at daycare centers and preschool facilities. This currently exists for hospitals and K-12 schools, but does not exist for childcare centers and preschools. AB 495 was drafted with immigrant families' unique hardship in mind. Families are scared to drive their kids to school at risk of being detained by immigration enforcement. And just to put this in context, we know what's been happening in our state over the past several months, where parents have been arrested and separated from their kids. And we also know that this administration has had a policy of separating kids from families, including locking them in cages along the border. And so this is about making sure that if parents are separated from their kids, that there is somebody who can step in, who they have designated to provide care and custody of those people until such time that the parents are unified with their kids. This bill empowers these at-risk families with options and tools to ensure that their children are protected from adverse immigration enforcement action. And I have to address what I think has been glaring and intentional misinformation that's been put out on this bill throughout the discussion of this bill through the legislative process. First of all, there already is a process where somebody can do a caregiver affidavit. That is existing law in California. Unfortunately, because of the misinformation and opposition that's been stirred up on this bill, the author took that out of the bill. So let me just make this very clear. The Senate amendments removed the provisions in this bill that would have allowed a non-relative extended family member to utilize a caregiver's affidavit authorization. So in the course of the debate today, if people bring that up, that's not in the bill anymore. So the most controversial piece of this bill is off the table. What this bill does is narrowly focuses on, one, making sure there are model policies for preschools, and two, making sure that we are building on the existing network of laws to provide families the tools in the case that parents are not able to care for their kids because they've been arrested and detained and deported and not able to care for their kids. So once again, this bill was recently amended to address opposition's concerns and incorporate technical assistance from the Department of Social Services. At the core of this is not about, creating a situation where strangers can take custody of kids and put kids in harm's way, contrary to what opponents have said. This is about building on the existing tools and network of laws that exist in California to ensure that immigrant parents who are cruelly being separated from their kids and being arrested and deported because of this administration's immigration policy, and let's talk about that in the course of this debate as well, that they have tools to make sure their kids are cared for. This bill is a Latino Caucus and Legislative Women's Caucus priority bill. It is sponsored by immigrant rights groups, legal public aid organizations, family and children's rights advocates. At the appropriate time, I respectfully ask for an aye vote.
Thank you. Senator Ochoa Bogh, you are recognized.
Thank you, Madam President, and ladies and gentlemen of the Senate, thank you very much to representing Senator Araguin, who made some comments and clarifications to that, and hopefully I will be able to address some of the concerns as well. We had a very close eye at this particular bill, and I do rise in opposition to Assembly Bill 495 for the following reasons. And though I appreciate the author's work on these most recent amendments, I still believe that the bill still misses the mark when it comes to protecting California's children. In conversations with my constituents, I learned that many of them weren't aware of the Caregiver Authorization Affidavit process until they heard about AB 495. This bill, in its amended form, has brought forth a magnifying glass to the existing law and exposed the massive safety risk our current caregiver authorization affidavit process poses. To be clear, I'm absolutely in alignment with the author's desire to ensure that all families have a plan for unexpected circumstances and that a reliable and trusted relative can step in to care for a child in that instance. But I speak from a perspective of a mother, a former educator, and school board member when I say that the amendments to this bill still do not adequately address the lack of accountability in existing law when it comes to verifying the identity or suitability of a potential caregiver. It seems unbelievable that an individual could assume care of a child and make medical decisions for them without parents' consent. And all it takes is simply filling out an 8-question form that is not required to be notarized, checking a box to indicate that they are a relative, and presenting a form of ID that is never verified for authenticity. And in the case of using a Social Security or medical card, could be an ID without a photo. And yet, even in its amended form, this bill still allows just that. I will not be supporting this bill today because I believe that if we're going to update existing law at all, we should be strengthening accountability for caregivers, enhancing oversight of this process with thorough identity verification measures, and creating a system that puts the safety of our children above all else. So with that, I respectfully ask for a no vote.
Thank you. Senator Durazo, you are recognized.
Thank you very much, Madam President. In today's America, we have a president who takes parents from their children. Just think about that. A president who takes parents from their children. And all that they are asking is to be able to prepare for the unexpected. They live with the fear that when they walk their child to their first day of school or go to the grocery store or head to work in the morning, they may never return. Who here has to face that fear? Children are left crying at the school drop-offs, unsure if they will be there, if their parents will be there when the bell rings. Members, with our communities under serious, violent, evil attacks, it is our responsibility to ensure students and families are prepared and protected. This gives the families some security. So would you rather care about the suitability of a caregiver wording on a form? Or would you rather have a child end up in a cage? Would you rather have a child end up not with the mother's choice of who should take care of that child? Let's talk about the child's well-being. Let the mother decide today who she chooses is the best person to take care of her child if, unfortunately, if she is picked up and detained and arrested and deported. Let her have the right to pick who will take care of her child. And none of us has the right to take that away from that mother. I respectfully ask for an aye vote.
Thank you. Senator Rubio, you are recognized.
Thank you. Thank you, Madam President. And ladies and gentlemen of the Senate, I rise in strong support of AB 495. And I also want to highlight some of the misinformation that's happening, because I think I heard it on the floor once again. I keep getting calls from my community saying that it's inappropriate for a person, a stranger, to just go in front of a child and say, I want that child and that child. That is not what the bill does. It's so unfortunate that people are hearing things that are not accurate. I want to agree with my great colleague from Los Angeles. What she stated right now is really important, because when children are being taken away to strangers after parents are deported, we don't care where the child lands. So shouldn't we be caring about what happens to child before the parent is taken away? The parent here is the one that's making the decision. The parent is the one that's saying, I trust that person. It's not a stranger. And we just heard the great senator who presented the bill very clearly state that the provision that allows a stranger to take the child is no longer in the bill. And I also believe that family members, mothers, do have, someone other than a family member that they trust. But again, because of the controversy, it was taken out. So right now, we only have in this bill the ability for a family member to take care of a child. And so it really baffles me that we're okay with families being taken away on the street, children being left alone, and we're not making a big deal out of that. Children end up in foster homes with strangers, end up in foster care with strangers, and we're not concerned with that. In this particular instance, we want a parent to be able to choose that loved one, that family member that best knows the child, to take care of their child. We often have a power of attorney when someone cannot make decisions for themselves. I equate this to this. We give the person the ability to make that decision. When they're not able to, then that person takes care of that child. I just want to say, I want to be clear, and I hear it again, that strangers are just picking up the children. That's not the case. It is a process that is authorized, that it's legal. And in this case, we see so many children struggling with strangers because they're left alone after these rapes happen. So again, I'm just really concerned that we're not concerned with the children being left with strangers in homes alone, being left at schools without a parent coming home. But now we're concerned about questions in a questionnaire. Let's be a little bit more sympathetic to what's happening. And I ask for an aye vote. Thank you.
Thank you. Senator Sayarto, you are recognized.
Thank you, Madam President. And colleagues, I rise in opposition to AB 495. This bill imposes sweeping new mandates on schools, child care providers, and courts that are costly and duplicative and problematic in their execution. AB 495 significantly expands the caregiver's authorization affidavit process by redefining relative and allowing individuals to use these affidavits without a parent's signature, court seal, or notarization. Eliminating these verification requirements weakens parental rights and creates the risk that someone could improperly assume authority over a child's medical or educational decisions without a parent's knowledge. And I understand they said this part has been taken out. Well, if that part has been taken out, the current law already provides adequate tools for parents to designate guardians or caregivers. AB 495 instead lowers safeguards that protect children and families. And let's talk about that current law. I've raised 3 daughters. We've enrolled them in schools. You go through a process when you enroll your children in schools of identifying not only who the parents are, but who the backup parents are, who the grandparents are, who's supposed to be called in the event of an accident or something else. Because parents aren't always just separated from their kids from immigration issues. And in fact, I would offer that parents are often separated from their children from other things, like a parent gets in an accident or parents get into an accident and they're unable to get to their children. Perhaps they're dead. That happens. That happened to me. So there's a lot of reasons outside of immigration and that kids get separated. And that's why there's already measures in place. And if that's not happening, that's an education problem. Schools should be making sure that this process gets done when kids are enrolled. If they're mass enrolling kids and not getting this information from whoever it is, whether it's somebody that's not a legal resident and they're enrolling their kids, or somebody that is, they have to know who to call, and they have to be able to be checked out. They have to have a license when they get there and say, yes, this is me. And if there is no one, we have a process for that too. The police do take them in custody. They don't throw them into a cage. They become wards of a court. And the court has to determine who it is the next of kin. Who it is the next person to call. Who's the aunt? Who's the uncle? And if it's a funny uncle, maybe not him. Right? That's what the court's job is. So this bill is not doing anything that we already don't have in place. And the reason we have it is because people aren't taking advantage of the authorization process that already exists. I say we go back to being that's an education problem, not a problem for us to solve here in the legislature in reaction to some of the hyperbole about some of the immigration issues that are out there. Now, I'm not saying they're not happening, but I am saying that a lot of instances are and making it sound like it's happening all the time everywhere, and it's just not. So this bill also imposes significant new costs on the state and local governments, and it does not provide the resources to pay for them. The Department of Social Services estimates that more than $5 million annually in new staffing will be needed, while courts and schools face millions more in workload and policy mandates. These dollars would be spent on bureaucracy and compliance rather than on classrooms and families. AB 495 takes the decisions that rightfully belong to parents and weaken their authority, leaving families vulnerable. I respectfully ask for your no vote.
Thank you. Senator Weiner, you are recognized.
Thank you very much, Madam President. Colleagues, I rise in strong support of AB 495. And first of all, I want to thank and acknowledge the author, who has put up with quite a bit of personal abuse relating to this very righteous bill because of misinformation and some conspiracy theories that were circulating out in the community. And it's really unfortunate and tragic because this is a really important bill. And fundamentally what this bill is about, because this original law was created in the 90s, because anytime you have parents and children who are separated, whether it's because of incarceration or deportation or whatever the case may be, that parent should be able to plan in advance for what happens with that child in order to ensure stability and continuity for that child. And what we don't want is for these kids to be just routed into the foster care system. That should be a last resort, and it's an incredibly important system. But if there's a way to avoid having the child go into the foster care system, and we know that kids don't always do well in the foster care system, if there's a way of avoiding that, we should do it, and we should empower parents to do that. And this bill is particularly salient now. And the senator from Los Angeles and the floor manager described it, I think, very well, that we have a situation where people in this country are being just snatched by ICE and bounty hunters and whoever else, just taken, and we don't always know where, and disappeared. And can you even imagine in a family, it's hard to even wrap your head around what that means, that a parent is just disappeared, and what's supposed to happen with that kid? And if we have a way of avoiding that and planning in advance and making it easier for parents to plan in advance, why on earth would we not do that? So I ask for an aye vote.
Thank you. Senator Valladares, you are recognized.
Thank you, Madam Chair. So as both a parent and a child care provider, having ran a preschool for years and years, I have one overriding responsibility. That's to keep kids safe. And that means protecting them not only from obvious dangers, but also from policies that could unintentionally put them at risk. And that's why I have deep concerns about AB 495. On the surface, it is framed as giving families more options in emergencies. But here's the problem. Under this bill, someone can sign a caregiver's authorization affidavit claiming to be an extended family member, and the schools and doctors are told they can rely on that form without any further investigation. In other words, a person could lie and with nothing more than a piece of paper, gain temporary access to a child. They can enroll them in school, take them to a doctor, or consent to medical care, all without true parental knowledge or consent. Now, as a parent, that terrifies me. And as a childcare provider, it really alarms me, because in my work, I have to know exactly who I am releasing children to. I have to ask for copies of custody agreements. I've had to look a parent in the eye and say, you can't pick up your child today because it's not your day. That's my responsibility. And you are putting huge liability on childcare providers in a time where it's already a challenging time to find childcare. This bill undermines that. It creates confusion, and it puts providers in the middle of disputes that should never hinge on a flimsy affidavit. Instead of clarity, we're creating huge liability on those who are entrusted with other people's children. Yes, the affidavit carries a penalty for perjury, but a penalty after the fact doesn't protect the child in that moment. And once harm is done, no fine or jail sentence can do that. We should be strengthening safeguards, not lowering the bar for who can step in and make decisions for our kids. Our children deserve airtight protections, not loopholes that can be exploited. For me, this isn't about politics. It's about safety. And as a mom, as a provider, as someone entrusted with the most precious lives in our community, I cannot risk supporting a policy that could put children in harm's way. I respectfully ask for a no vote.
Thank you. Senator Grove, you are recognized.
Thank you, Madam President. Colleagues, I could not agree more with my good colleague from Los Angeles and San Francisco regarding their statements, or some of their statements, on this floor. Every single one of us as human beings, regardless of party or what part of this state we represent, should deeply care what happens to a child if they are dropped off at school or preschool and their parents are caught up in a deportation or immigration circumstance or any other circumstance, but specifically to this bill, and that kindergartner or that child is standing out on the street corner waiting for their parent to come back and not have a place for them. The spirit of this law is real and needs to be addressed. My good colleague from Los Angeles said it should be the parent's right, the parent's signature. The mom should decide. The mother should make that choice in her direct comments. I wholeheartedly agree with my colleague, but that's not what this bill says. This bill does not say that. I need your computer. Mine's dead. Something happened. Sorry. I need the language. I want to read the definition of the language. My computer went down, and I'm sorry, so I can't get you the language right in front of it. The language in this computer, I actually have it on my phone too. The definition of a relative, someone who can self-identify under the penalty of perjury, which is an AB 109 crime. There's no penalty, no jail time. There's a veiled threat that you might get in trouble, but you self-identify. An individual can self-identify and claim, right? Thank you. And claim that they are a relative for the purposes of signing this caregiver affidavit. The relative definition, the purposes of item 5, permission to read.
Permission granted.
means an adult who is related to the child by blood, adoption, affinity within the 5th degree of kinship, including step-parents, siblings, and all relatives with a status preceding the words great, 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 grand, spouse of any of these persons, any of the ones I just listed, even if the marriage was terminated, death, or dissolution. If I was in this situation, my ex-husband's second wife and her 4 cousins in the 5th degree could go and pick up my granddaughter with a self-certified affidavit. Now let's go to the affidavit. The affidavit itself says, I don't have my laptop, so you have to forgive me. The affidavit itself, you have to go in to the 5th degree of a self-determined applicant for a caregiver in everything that I just identified, and it says the minor lives at home with and is and I am 18 years old. I'm the caregiver applying for this. The name of the minor's birth date, my name, and my home address. That's it. And then they say nothing else. And the facilities are held harmless. There is an affidavit in here, and that was the big issue on the affidavit, is it did not allow a parent's signature. If you go to the section where it says warning, it's a warning to the person applying to be the caregiver. Somebody that says there's someone related to the 5th degree of a divorce or delusion or death of a family member, step or otherwise. That person can go in and say, I, under penalty of perjury, am here to pick up so-and-so, this child, and my name is and my address is. You sign under penalty of perjury, which is, like I said, an AB 109 crime, and then it says warning. Educational agencies and healthcare service providers, okay, and the parent's signature, it's in red. It was amended out. There is no parent signature required. My good colleague from San Francisco said, parents should have the opportunity to pre-plan. My good colleague from Los Angeles said, it should be the mother's choice. Wholeheartedly agree. The mother, the parent, when I go pick up my granddaughter from childcare, I have to stick my face in a screening camera, show my ID, they print out a ticket, and I can go get her. It shouldn't be a self-identified person that walks in with a caregiver application that you can get online that says that I am entitled to pick up this child. The parent should decide that. The parent should say, if something happens to me, regardless if it's a deportation circumstance or any other reason, the parent should say, I want these 5 people to be called, these 8 people to be called, or whatever, to make sure that my child is taken care of. Again, the essence and the spirit of this bill needs to be addressed. No one, not anybody on your side of the aisle or on our side of the aisle wants a child left. Could you imagine the trauma? Being left and not even know where your parents are? There are things going on in this world that not everybody agrees with, I being one of them in certain circumstances, but the bottom line is that this law exacerbates the situation. It also says in this particular, it doesn't require a notary, no court, and not even a parent's signature. The only safeguard offered is the threat of committing perjury, which is the AB 109 crime, which doesn't even carry consequences. And this is the only section, the 4660 or whatever it is. I'm sorry, I don't have it up on my laptop because mine is down. But that section, every section of this bill talks about an immigration and deportation circumstance, except that section of the bill, which would include all children in the state of California. But in this particular case that I'm talking about, this bill, all children should be treated equally. All of them. Whether you're undocumented, illegal, whatever word you want to use, it doesn't matter. All children should be protected in this state by all of us, and this bill is not protecting those children. I worked 4 years on human trafficking, fighting this body to protect these children. You don't think these perpetrators are ahead of us like no tomorrow? No tomorrow. They are so ahead of us. You don't think you can get those kids' names online that go to that school? I'm asking you to protect these children. Have the parents decide. Fund the schools. I'll help you. I'll join you to fund the schools, to educate children, to parents, to say, listen, and nobody wants to expose somebody here who's illegal or undocumented, right? So make sure all parents, every parent, has a pre-authorized plan, like my colleague from San Francisco said, and my colleague from Los Angeles said. pre-authorized plan to have your child pick up if something happens to you. A pre-authorized plan. Don't let someone come in and say that they are a caregiver, they pulled this information online, they filled it out themselves, and all they had to do was put their name, the child's birth date, the person's name, and their address. You don't even ask for a phone number on items 1 through 4 that's required by this affidavit. Respectfully ask for a no vote. Fix this bill. We will help you. None of us want a child left behind. Not one. We want that child taken care of them. We want that child with grandma and grandpa. We want that child with the neighbor they grew up with. We want the child with the parent. But if something happens, we want that child taken care of and not left at the hands of strangers that somebody else made a determination for a parent. Respectfully ask for a no vote, and let's fix this, protect these kids, and do it right.
Thank you. Senator Alvarado Gil, you are recognized.
Thank you, Madam President. I rise today to express my firm opposition to Assembly Bill 495. And I also want to say how disrespectful it is that on such an important bill for debate that so many of our colleagues have left the hall today. Every single person on this side of the aisle is mourning the loss of a great figure in conservative policies and education for children. But yet, we are here. In today's America, and for decades, minor children have been trafficked across our borders, oftentimes by the very family members paying thousands of dollars to a coyote or a smuggler to bring their children to America. Who is responsible for separating that family? Who is responsible for putting that child's safety at risk? Enough with the hateful rhetoric. Enough. This bill is a direct assault on parent rights and puts children in harm's way. This bill is not about protecting kids, that is portrayed to do, but it's about removing the safeguards that keep them safe. As written, the bill would essentially allow a non-parent to claim guardianship over a child at their school. It permits these caregivers to perform functions that parents normally would, such as enrolling children in school and consenting to all forms of medical, dental, or mental health care. Even some of the serious treatments that we debate here on this floor, such as sex trait modification, all without parental consent or court oversight. The burden is on schools and daycare centers to verify the identity and the relationship and the legitimacy of the adult presenting the authorization affidavit. And although schools would be protected from liability if a child is handed over to a stranger or trafficker, who then will be responsible for the potential harm of that child? This bill is washing the hands of liabilities from our schools, but yet putting them on the front line to make decisions about who they would hand my child over to without proof, without background checks, without court review. This bill essentially opens the door for abusers and traffickers to gain legal authority over a child, effectively cutting parents out of their life-changing decisions about education and medical care, and that the trust and security of children, their needs, could be replaced with tragedy and a future of trauma. I wonder, we can all see this as a public safety risk, both those who are on the other side of the aisle and here. But yet, looking at this as a public safety bill, why was it never heard in the Public Safety Committee? I'm baffled by that. In order for us to board an airplane, we must have a federal form of ID. We must have our biometrics checked. We must have a boarding pass that checks all of our documentation to make sure we are who we say we are to get onto that plane. We have to take out things from our pockets, pour out our liquids, take out our electronics. Gratefully, we can keep our shoes on now. But that's just to board a plane. Yet we are saying to take a child in this state, we are going to have less regulations to protect the fate of a child? These are not hypothetical risks. These are real loopholes that invite the exploitation of children. We must do everything possible to protect the vulnerability of our children and not make it easier for bad actors to take power over them. Parents are the first and most important defenders of their children. I made 3 children in this body, and every day that they grew in my body, I feared of what decisions I needed to make to protect them and to guide them and to educate them. No one can take ownership of my children and be able to make the decisions that I, as a parent, can make for them. This bill pushes aside parents and opens the door to danger. For the sake of our children and the safety of American families, I urge you to rethink your position today. I ask you to say no and say enough of government overreach into the nuclear core of the American family. We don't know who drew the maps, but we know who built the cages, and it was not President Trump, because Biden admitted to it under the Obama administration.
Can we please stick to the merits of the bill? Thank you.
Madam President, I am responding to cages that were brought up in a previous floor discussion.
Say a point of order. What is your point of order?
She's not speaking to the bill.
Like I stated, Senator, please stick to the merits of the bill.
Yes, Madam President, asking you kindly to acknowledge that the topic of cages was brought up in this floor debate, and I was simply responding to that.
Thank you. You have responded. Can you please stick to the merits of the bill?
Thank you. I think with that, I'm going to mic down and ask for a no vote.
Thank you. Senator Wahab, you are recognized.
Thank you. I rise in support of this bill, not only as a co-author, but as a former foster youth, as well as an individual who has a doctorate in social work. And I want to highlight that the conversations around this bill has largely been around fear-mongering. It is nothing more than that. This bill allows for parents and families to make a decision in case something happens to them. And I want to highlight that this bill is about a temporary request for the child, that the parents choose, that the parents decided and signed off on, and the courts approved. And it is for the stability of a child. When we talk about children, everyone is talking again about fear-mongering and this and that. It is not about that. It is about the dignity and the safety and the stability of a child. I have often said that schools are one of the most stable places for children, including kids in foster care. When they move from home to home to home and they have a different experience than many of their colleagues, school is one of the safe choices. We want to provide more stability to the child when their family may take a hit. For example, my father was murdered. What does a family do? A car accident, let alone a raid, immigration concerns, deportation, missing family members. What happens? This is long overdue. This is very much needed for families to make a choice for the best interest of their child when something bad happens. And I want to be very clear, and I often try to rebut what is being said. Some have said that strangers or traffickers will take a kid because there's no oversight. Again, a caregiver's authorization affidavit does not grant legal custody. It does not. It only allows for temporary decisions like school enrollment and routine medical care, again, supported by the courts after an investigation, and the courts deem it appropriate. Some will say the bill creates a non-relative extended family member category that's too vague and unsafe. This category has existed in California law for decades. Parents lose control over who cares for their child. Again, this empowers parents to make the choice for their family. We are not stripping a single parent away from their rights. We're enhancing their rights. It is the right thing to do for all families, whether they choose to utilize this law as something that helps their family or not. Again, I believe in giving families the choice to do what's best for their children. So I respectfully ask for an aye vote. Thank you.
Thank you. Senator Menjivar, you are recognized.
Thank you, Madam President. Colleagues, I stand with great pride to support my assembly member from the San Fernando Valley, where we represent an area that is the #1 targeted location in all of LA County, where just yesterday, individuals from the valley were held at gunpoint, pulled from cars, kidnapped from 4 different locations in the district that we both proudly represent. I am astonished to hear on the other aisle this uproar that the concern, I think, invalidated concern regarding what is happening, yet this is a response to the attacks that we're seeing in our community. It is not a concern to the actual cause of this bill. This bill wouldn't have needed to be necessary if none of this was happening in our communities. My fellow assembly member wouldn't have had to jump to the call if our constituents were not being kidnapped in our backyards. This is a response. It clearly states in the analysis that it's at the discretion of the court to deem this individual as the caretaker of the kid. In the San Fernando Valley, we are hearing concerns from caregivers who the kids that they care for are telling them, my mom said that we need to find someone in case they're not home when we get out of childcare. Where parents are talking to childcare providers saying, we're looking to figure out who we're going to leave our kids with if we are taken and kidnapped. Because they are kidnapped, and oftentimes it takes weeks for legal representation to actually be allowed to talk to them. This bill was thoughtfully thought out, and it only enhanced what is currently in statute right now. I am not a parent. I can only imagine what it would feel like if I was taken from my home, not knowing who was going to pick up my kid from school. I can only imagine as a kid what it would feel like if I was abandoned or felt abandoned at school because I wasn't picked up, not knowing that my mom or parent was taken. The assembly member has a personal connection to this, having seen her father or having heard her father experience his mom be kidnapped in front of him. These are the stories of so many immigrants, Latinos, not just in the San Fernando Valley, in the state of California. I am proud to stand with her. I thank my colleagues who are helping with this. We need this additional protection because families are being broken up. Respectfully asking for an aye vote.
Thank you. Senator Cabaldon, you are recognized.
Thank you, Madam President. Just one notation on this debate, which is the law that is at issue here, the Caregiver Authorization Form statute that this bill amends and makes minor updates to, was carried in 1994 by Senator Newton Russell, Republican from the Glendale area before he was replaced by Adam Schiff. This is a bipartisan issue, a bipartisan approach to assuring that families are kept together and served properly. So I believe Newton Russell was right when he sponsored this legislation and received overwhelming bipartisan support, and urge an aye vote on this bill as well.
Thank you, Senator. Senator Gonzalez.
Thank you, Madam President, and thanks to my colleague from Napa, because I actually just looked that up as well and was very astounded to find this information out. So very good job there. And I want to just say thank you so much as chair of the Latino caucus to the good assembly member for bringing this forward, who has worked so very hard. We know that this family preparedness is so very important as the President Trump's administration is literally separating our families. When you go on, I hate to even go on Instagram because I've seen the stories of, I saw one story yesterday where a child was literally hugging his mom so hard, crying. He said, please, please. And he was praying, do not take my mommy away, please, please. And he's pleading. And if you just watch this and you think, oh my gosh, this child is pleading. He hugged her so hard. She was crying and pleading with him, and they stuffed both of them in the car. And then they ripped him apart from his mother. I can't even imagine as a mom how that would feel. And what happens with that child? What happens? Do we just let them fall by the wayside? Or do we have a plan in place? And again, let's not go on with misinformation. It's very dangerous to say that there are, I'm not even going to address it because honestly, it's so dangerous to even repeat what my Republican colleagues are saying. Again, it tasks the Attorney General to create model policies for childcare providers to ensure they have the tools and information they need to respond to ICE raids. Second, it creates a new temporary, which is not being talked about by my colleagues on the other side of the aisle, a temporary joint guardianship process that allows parents to designate a guardian. In fact, I use that often because I actually am up here 7 months out of the year and I have to designate my really close family friend to go pick up my child oftentimes. Yes. And third, it prohibits licensed child daycare facilities and license-exempt state preschool program facilities from collecting information, as we all have agreed is so very important. But her bill establishes the joint guardianship process that allows parents, once again, parents, to designate a guardian in cases of egregious immigration enforcement. I ask my Republican colleagues to please urge you all to not spread misinformation. It's dangerous. The rhetoric is not okay in these circumstances. And I ask members to join me in supporting AB 495.
Seeing no other member wishing to speak, Senator Edegin, you may now close.
Thank you, Madam President. I want to thank my colleagues for the very robust debate. And I want to particularly thank the Senator from Bakersfield for her comments. And I think her sincere concern for the well-being of children in California. But I just want to reiterate that this bill has been amended to, I think, address the overarching issue that has come up in the debate by the Republican members. So I want to cut through the noise and really focus on what this bill does. And perhaps maybe people wrote their talking points before the bill was amended. I certainly understand that, but I want to address what the bill does currently. And I just want to put this in context, why we need this bill. As was stated, the caregiving affidavit is already existing law in California. The only change that this bill does with the amendments is to amend the definition of relative to be more inclusive of the type of familial relationships that people have in California, blood relatives and other types of familial relationships, and to also say that a consular card can be a form of identification to satisfy the requirements of the affidavit. Those are the only substantive changes to Section 4 and 5 of the bill, which amend the provisions of the caregiving affidavit. The references to non-relative extended family member, those have been stricken from the bill. That's no longer in the legislation that's before us today. And if members have concerns about the affidavit process, that would be more appropriately focused through separate legislation that could be considered by this body next year. So just put this in context, what we are seeing in California are parents being taken off the streets and separated from their children, and their children don't know where their parents are, and they may never even come back. And so I wish this bill wasn't needed, but it is. And so what this does is build on the existing framework to, one, ensure that There is a joint guardianship process, so references to the fact that you can sign a piece of paper and there's no notarization, or the court doesn't have to verify that, and they could take custody of the person. That's not true. Custody of the minor, that's an issue that's addressed through a separate legal process, and what this bill does is expand upon that to create a process where the parent can request a joint guardian, a person that they designate. The court will review and approve that request, and there's an annual process to verify that request. So yes, the parent will be involved in determining who that guardian is to have custody over that kid. Moreover, the bill also ensures that, like with hospitals and churches and schools, that we have model policies around what happens if immigration comes into a daycare facility or preschool. I think we can all agree that I should never have to go into a daycare or preschool and to arrest parents or terrorize kids. But that's a sad reality now in California. And so if that is going to happen, because this administration has rescinded the previous federal policy to say that sensitive areas like schools and hospitals and preschools, places that were safe havens for people, that's fair game for immigration enforcement, that those facilities, those preschools and those childcare facilities should know what to do in the case of immigration coming into those facilities. I think that's fair, like we're requiring other industries, like whether it's hospitals or schools, to implement similar policies and protocols. So that's all that the bill does. This is not about stranger danger and allowing random people to take kids and to put kids in harm's way. That's not what this bill does. This builds on existing law that exists in our state, existing legal processes, and says in the case if somebody is deported or is separated from their kid, that they are designating a person to take custody of that kid so that those kids are not being left behind. We cannot leave immigrant children and children in California behind with nobody to take custody of those kids. That's what this bill seeks to address. I want to thank the sponsor for her courage and leadership in bringing this forward, who's faced enormous harassment and misinformation, but who's doing the right thing to stand up for her families in her district and families all over the state of California. Let's cut through the noise and let's do what's right for our kids and families in California. I respectfully ask for an aye vote.
Secretary, please call the roll.
Allen. Aye. Alvarado Gil. No. Archuleta. Aye. Adeguin. Aye. Ashby. Becker. Aye. Blakespeare. Cabaldon. Aye. Caballero. Cervantes. Aye. Choi. No. Cortezi. Aye. Daly. No. Durazo. Aye. Gonzalez. Aye. Grayson. Grove. No. Hurtado. Jones. No. Laird. Aye. Limon. McGuire. Aye. McNerney. Menjivar. Aye. Nilo. No. Ochoa Bogh. No. Padilla. Aye. Perez. Reyes. Aye. Richardson. Aye. Rubio. Aye. Ciarto. No. Smallwood Cuevas. Aye. Stern. Aye. Strickland. No. Umberg. Aye. Balladares. No. Wahab. Aye. Weber Pearson. Wiener. Aye. Ashby. Aye.
Senator Adeguin moves a call.